All right, we're now live. We're going to go ahead and call number 35, CL 213297H, Discover Bank versus Cindy Mata. Is Cindy Mata present online or in person? I don't believe she is in person, although we do have some individuals that are here. Cindy Mata. If you're on mute, please unmute yourself. Cindy Mata. This case is set for default judgment today. We're going to take judicial notice of all documents in the court's file, including the filing of this action on September 27th, 2021. Citation was issued on the same day. Defendant was served on the same day. It was returned on September 29th, 2021. To date, there's been no answer on file. The name of Cindy Mata was called out 3 times. Since there is no response, you may proceed with your default judgment.
Okay, thank you, Your Honor. We filed a motion on January 25th and served defendant through regular mail. And we also filed our notice of hearing and mailed that through regular and certified mail to the defendant. Our motion has a business records affidavit attached by Discover Representative Patrick Sawyers, along with a card member agreement and a balance matching statement from February 2019, and affidavit of attorney affidavit non-military service and certificate of last name address. Since the defendant has not filed an answer and was properly served, we're asking for a default judgment of $17,725, post-judgment interest at the statutory rate of 5%, and court cost of $370.15.
All right, court will go ahead and grant default judgment in the principal amount of $17,725. Cost of court in the amount of $370.15 plus judgment interest in the amount of 5%. That relief is granted. We will sign off their default.
Okay, maybe excused.
You're excused. Thank you.
Okay, thank you.
All right. All right. I do have several individuals that are present here today. We'll start off with number 25, Maria Ibarra. Maria Ibarra. All right. Miss Ibarra, Ms. Carlos, can you send her to the back? This is number 25. Mr. Kettler, this is Maria Ibarra. She'll be logging on here online in person. She is here in person, but she'll be using our computer that we have set up.
Sure thing, Judge.
Hi, good afternoon, Ms. Ibarra.
Buenas tardes.
Good afternoon.
Ms. Ibarra, you are here in CL 184613H. Are you represented by an attorney, ma'am?
¿Estás aquí en este caso hoy? ¿Lo representa un abogado?
No,
No.
And have you had an opportunity to confer with any representative from Portfolio Recovery Associates with respect to this debt?
¿Algún representante de Portfolio Recovery tocante esta deuda?
no, es que yo te había juntado las tarjetas con una compañía que me iban a dar, que estaba haciendo un solo cobro, pero durante unos meses me estuvieron cobrando y después ya no supe.
No, I had gotten all my credit cards put together with the company, and I was only making one payment, and I never got any more notifications.
All right. And to your knowledge, was this debt from Portfolio Recovery Associates included in that debt consolidation?
¿La deuda de Portfolio Recovery estaba incluido en ese programa?
Pues supuestamente las tarjetas que tenía que estaba todo incluido.
Well, supposedly all the credit cards that I had, it was all included.
Mr. Kettler, do we have any information about what credit card or what kind of debt this is?
We do, Judge. This is a third-party debt buyer case arising from an account with Synchrony Bank, a Walmart account.
All right. Does that ring a bell, Ms. Ibarra? A Walmart account or Walmart credit card?
¿Era una cuenta de Walmart?
Sí.
¿Una tarjeta de crédito reconoce?
Sí.
Yes.
And was that included in that debt consolidation?
¿Eso estaba incluido con la consideración?
Sí.
Yes.
Era una de las principales.
That was one of the principal ones.
And did you ever give, well, I guess you have not exchanged that information with any representative from Portfolio, correct?
So usted no ha hablado y le ha dado esa información a esta compañía de portfolio, ¿correcto?
Es que siempre me hablan en inglés y pido hablar para explicarles y nomás quedan de regresarme la llamada y ya no lo vuelven a hacer.
It's they're always calling in English, and I've asked to speak to somebody in Spanish, and then they'll say that they'll return my phone call, but I never get a call back.
Mr. Kettler, any information or any suggestions on how she can get in contact with somebody? Obviously, this might be a situation where she just needs to forward that information on the debt consolidation and to make sure that it may have been included, it may not have been included, but she has still some homework to do. But I obviously would like for her to communicate with somebody in the Spanish language. Do you have anybody that she can get in contact with?
Judge, I don't know a particular person. However, to the best of my knowledge, they should have at least one person or two people on standby for Spanish calls. I could provide Miss Ibarra a general a phone line she could call or have her debt consolidation company call on her behalf.
All right, what number is that?
That is going to be 866
So give me 1 second. 8,
Yes.
6, okay.
456 3744. And Judge, if you'd like, I can provide her the same attorney contact information I provided in previous hearings of attorney Megan Hale.
Yes, please.
And I'll also put that in the chat for everybody else's benefit if they like it. It's going to be 262 796.
796,
Yes, sir.
okay.
7890.
All right. Now, for everybody who's logged on today and has a case, please make sure you write that number down. That's an important number that all of you are going to need to write down. Name of attorney Megan Hale, Hale, area code 262-796-7890. So please make sure everybody has that down. It is now been added to the chat. And so if you don't have it, please look at the chat and the information is there. Okay, Ms. Ibarra, since this is your initial appearance, Mr. Kettler was seeking to take a default judgment. Obviously, that will not happen here today since you did appear in person. I am going to take your appearance here as a general appearance, and I'm going to reset your case for May the 11th, 2022 at 2 o'clock or 9, or do we do 9:30? 9:30. At 9:30, I'm sorry, 9:30. May 11th at 9:30. May 11th, 9:30. In the meanwhile, the number that was provided to you, we have two numbers and we'll give those two numbers to you. Carlos, if you have something to write with, please write down the 866-456-3744, as well as the 262-796-7890. I'm asking Ms. Ibarra to please make contact with the representative, either Megan Hale or another representative from Portfolio. See if something can get worked out. Otherwise, we'll see each other on May the 11th for a status. Right. Any questions, Ms. Ibarra?
¿Tiene alguna pregunta?
Que si llego a algún acuerdo, hablo, y si llego a algún acuerdo con ellos de dar pagos, de que me acepten los pagos que pueda dar, ya no regreso a esa puerta.
So I'll call, and if I can come to an agreement with them, like if I have to make any payments, I don't have to come back on the 11th of May?
You don't, as long as they submit paperwork that there is an agreement. And my suggestion to you would be to log on anyway, or to come by so that we can have everything straightened out and make sure that we are on the same page. But you don't technically have to, but I would suggest that you do.
Okay.
All right. You're excused, Ms. Ibarra. Thank you so much.
Thank you.
All right, let me go ahead and call number 41. Number 41 is Zaida Ortiz. Ms. Ortiz, if you can just come to the back, please. Is it Zaida? Zaida. All right. Right up back over here.
Slowly, but yes, I can.
All right. Ms. Zaida Ortiz, good afternoon.
Hello, sir.
We are here in CL 194392H. Before I get started, I must ask, are you represented by an attorney, ma'am?
No, sir.
All right. Have you had any communication or any information that was exchanged between you and Portfolio Recovery Associates about this debt?
Yes, sir. I called them yesterday and I paid the pending amount in full. I do have a confirmation number.
Okay. Mr. Kedler, if she were to give you that confirmation number, would that help you?
Judge, I could go ahead and relay that back to the firm, but to be honest, I don't really know if it would. But if I think for the purposes of the hearing, that helps a lot. If she says she's paid in full, then perhaps we could reset for status, and that may be enough time for the payment to clear and for them to send in their dismissal.
Perfect. Let me go ahead and do that, Ms. Ortiz. I'm going to go ahead and reset the same case for May the 11th. May the 11th at 9:30. You can log on via Zoom just to confirm that this has been paid. You may be working that day. If you can just maybe log on via Zoom. And if it has been taken care of, then it'll be a very short hearing.
Okay, yes,
Okay.
Judge. Yes,
All
sir.
right. Perfect. So at this time, I'm going to go ahead and take your appearance as a general appearance. No default judgment will be taken. We're going to note that you are here in person, that there has been an agreement reached, and the case is reset for status to May 11th.
Yes, Judge.
All right. Any questions?
No, sir.
All right. Have a good day. Thank you for coming here today.
Thank you, sir.
All right. Let's go ahead and call number 53. Number 53 is Angelita Valdes. Thank you. This is CL 203068H.
Okay.
Crown Asset Management versus Angelita Valdes. Angelita Valdes is there. Ms. Valdes, can you hear me?
Yes, sir.
All right. Ms. Valdes, before we get started, I must ask you, are you represented by an attorney?
No, sir.
All right. And have you had any information provided to you, or have you spoken to any representative of Crown Asset Management? I believe this might have been a Bell's account.
No, sir. I haven't talked to nobody.
All right. Mr. Kettler, is this a case where she would probably be best getting in contact with Megan Hale?
I believe so, Judge. But in an abundance of caution, I'd like to provide both of those numbers as well.
Okay. Can you go ahead and provide them both, and we will jot them down for her. Make sure she has them.
Yes, sir.
Do you know what, can you put the other one on the chat, and then that way I can have them. That way I don't always have to be asking you. I could just written.
It is. I'm sorry, Judge. I have it listed as Ralph Sturm's secondary number. It's a general collections number.
Okay, and either one of those numbers is a good number for her to reach?
To the best of my knowledge, yes, Judge.
Okay. The court, ma'am, is going to go ahead and provide you with those two numbers. On your way out, we will provide you with those two numbers so that you can have them. I'm going to take your appearance here today as a general appearance, meaning a default judgment will not be taken out against you. I'm going to reset this case for a status on May the 11th. Please know that we will also give you that day, May the 11th at 9:30 in the morning. And I would like for you to make contact with them so that you can communicate with them about this debt, and they can provide you with all the information that I think you might be looking for. Okay. Do you happen to have any questions here today for me? All right. I'm going to go ahead and provide you with those two numbers on your way out. Please make sure that you come by. If my bailiff is not there with you, please come by and we can provide you with those numbers on your way out to make sure you have them. Okay.
Okay, thank you.
Any questions?
No, sir.
All right. Thank you so much.
Numbers right here.
Okay.
Court's going to call Juana Zamora. This is CL 200184H. TD Auto Finance LLC of Chrysler Financial versus Juana G. Zamora. Thank you. Juana G. Zamora.
Me quito de esto.
No, también. Nomás hable en voz alta.
Mande.
Okay,
Yes,
Ms.
ma'am.
Zamora, before we get started, let me ask you, are you represented by an attorney?
¿Lo representa un abogado?
No,
No.
no, pues no.
And Ms. Zamora, have you had any communication or any conversations with any representative about this debt, which I suspect is over a vehicle? Is this a vehicle debt, Mr. Kettler? Is this a kind of a surrender of a vehicle that was sold at auction and there was a deficiency and you're seeking to collect for that deficiency?
Yes, Judge, that's accurate.
Okay. And have you spoken with anybody about that, Ms. Zamora?
¿Ha hablado usted con un
Yes.
representante tocante del vehículo?
Cuando mi hijo habló con el de la agencia y le habló para decirle que lo iba a entregar. Mi hijo entregó el mueble.
My son spoke to somebody at the dealership that he was going to turn in the vehicle, and he turned in the vehicle.
Lo levantaron de ahí de la casa.
They went and picked it up at the
Sí.
house.
Okay. And who was the vehicle's name under? Was it under your name or your son's name?
¿De quién estaba el nombre del vehículo? ¿Suyo o su hijo?
De los dos. Pero
Both.
como yo firmé para que se lo soltaran a él, por eso lo soltaron. Pero él lo entregó.
Both of us.
Ujú.
But since I signed so he could get the vehicle, he returned it though.
And how old was he when you signed?
¿Qué edad tenía él cuando usted firmó?
Pues hace como más de 2 años.
¿Qué edad tenía él
Él tiene
en esa fecha?
48.
Cuando usted firmó por él?
Sí. 48, 49.
48, 49.
And were you a co-signer or were you the primary signer for the vehicle?
La primaria, la que está
Sí,
firmando.
arriba, sí, porque como pues por el crédito, y se le soltaron el mueble.
Yes, because of the credit, so he could get the vehicle.
Okay. And have you spoken with anybody about, see what happened here, ma'am, and this is probably something that you probably were not aware of. You took out a car and you took out a car, you couldn't make payments on that car anymore. And as most people do, most responsible people do, they call the company, say, we can't afford the car anymore. And they surrender the vehicle. It's not repossessed, it's turned over. What the bank then does is the bank then takes it to an auction and they sell it in what's called a fire sale, meaning they're not looking to get the best price, they're just looking to get a price. And the difference, that discrepancy between what it sells for and what you owed, they're now seeking to recover that from you. Were you aware of that?
¿Sabía usted eso?
No, es que a mí no me dijeron, no, o sea, no nos dijeron nada más. Mi hijo no pudo pagarlo porque pues se acabó el trabajo, fue cuando la pandemia, mi esposo se enfermó, yo me enfermé. Y...
No, didn't explain anything like that. My son could not keep up with the payments anymore because he's lost his job because of the pandemic. And then my husband got sick.
Mi esposo murió también.
And then my husband then passed away.
Okay, Mr. Keller, I know that this puts you in a position where you're not, you don't have very much authority. At least I don't think you do at this point. And at this point, could you just at least provide me with how much, or at least information on the debt? How much are you seeking to recover? How much of that? What was the year of the vehicle? Just so I can give her some idea. Obviously, these are unfortunate circumstances where, these individuals are put in a predicament where they try to do the right thing, they do the right thing, and then they get caught up in this situation.
I understand.
Go ahead. Can you give me some information on the debt?
Sure, Judge. The current amount being sought by TD Auto is $18,374.99. And I believe you had asked for some additional information from the default about the vehicle.
Yeah, so it's you're seeking $18,374.99, correct?
Yeah, Judge.
All right, and give me some information about the vehicle. What was what's the year of the vehicle?
It's a 2000. I could give you year, make, and model all at once. It's a 2013 Chevrolet Silverado.
All right, and when it was taken over and when they surrendered it, how much was owed?
One moment, Judge. Let me review the pay history documents, which should be included as part of that default. The amount that's being sought should be all inclusive of everything. I'm showing that prior to the charge off, but immediately after the auction proceeds, there was a principal balance of $17,878.58, according to the business records.
All right. I guess what I'm trying to figure out is, you know, how much was owed at the time of that they surrendered the vehicle, and then how much was it sold up at auction? And obviously the difference is what you all are trying to recover of the 17,000. So was the vehicle worth, you know, 40,000? Did they owe 40,000? Did they sell for, you know, 20,000 or 20, you know, whatever? I'm just trying to come up with an idea. I
Sure,
just need to give her some information, because it seems to me she wasn't even aware of why she was being sued.
Sure, Judge. I think maybe the best place I could go back to is the contract that should be included as part of that default motion. The total sale price indicated as part of the contract appears to be $46,021.12. And with several payments on the account, and an auction proceed a little bit north of $13,000.
Okay, so it's sold at auction for 13,000 plus.
Yes, sir. At least
And-
according to what I have in front of me.
The sale price was 46. And do we know how many payments were made, or at the time of the surrender of the vehicle back to the company, how much was owed?
The exact time of surrender, I apologize, Judge. I'm having trouble finding exactly that point. I did find like the earlier point of the principal balance after that auction sale. I think that's some additional information that we could look into.
Okay. Okay, so here's what I'm going to do. In this situation, I still need to go and look at the paperwork that was submitted. But Mrs. Zamora, just so you can have an idea of what's going on here, because I have a feeling that you are clueless about what is happening here. And I'm glad that you're here today, because what TD Auto Finance is looking to do is to take out a default judgment against you in the amount of $18,374.99. Now, where does that number come from? It comes from the difference between the price of the vehicle that you purchased it for and you signed a contract to pay for, and the amount that it was sold at auction plus all other fees. So that is where the $18,000 comes from. Now, the difficult part is for you is that you don't have a vehicle and you still owe $18,374. And that is, you know, a difficult spot to be in, because I don't think that people are made aware of the fact that when you do the right thing and you surrender a vehicle back to the company, I guess a person's belief is that the obligation ends at that point. And based on the contract that you sell or you signed when you bought a vehicle, in the small fine print, it says that the vehicle will be auctioned and that you will be assessed the difference between the auction price and the owing price. And in this situation, they're claiming $18,374. Does that make sense, at least at this point, as it's being explained to you by my bailiff?
And why would they say that they sold it in auction, and if they had it at the dealership when we went?
You went to the dealership when?
Fue para la agencia cuando?
¿Cómo la GMC?
At the GMC?
Sí,
Cuando?
hace como 3 años.
Oh, about 3 years ago, more or less.
Okay, was that when you purchased it originally?
Eso era cuando lo compró originalmente.
Pues sí, yo no me acuerdo la mera verdad, pero sí fueron más de 2 años porque mi esposo pues ya tiene 1 año o 9 meses que falleció
I don't
y fue en ese tiempo.
remember exactly, but I know it's about 2 years more or less because my husband had died like about a year, 9 months ago.
No, I guess I'm trying to figure out, when you say it was at the dealership, when was it at the dealership? After you surrendered it or before you even purchased it?
O antes de que lo comprara.
No, cuando lo fuimos a agarrar,
When
ahí
we
estaba
went-
en la agencia.
When we went to get it, it was at the
No,
dealership.
I understand that. And you bought it at the dealership and you bought it for a price that you agreed to. And you heard the sale price was $46,000, more or less.
$10,000.
Now, what happened after that was all these things in life happened and you couldn't pay for it. And you surrendered the vehicle back to the dealership.
Y entregaron el vehículo.
And what happened was that you surrendered the vehicle and it went then to an auction and they sold it at the auction for $13,000 plus, which is not enough to cover the sale price, the original contract price of $46,000. That's where the $18,375 is coming from. Does that make sense?
No dijeron que fuera a salir en 46, nunca dijeron.
They never said it was gonna be at 46,000. They never told us.
No, si no, no agarramos.
So now we would not have gotten it.
Well, is that what the contract price is? Yeah, I have a copy of the contract,
Tengo una-
Zamora, and the contract does say 46,000. So that was a contract price that you signed for. Now, I understand that certain things happened and that you weren't able to make those payments. What I want to know is how can we come to an agreement? Because I think it's an unfortunate situation you find yourself in. And sometimes companies should, in my opinion, give a discount for some situations like this where they are sold at auction. And the reason for that is because, you're not given an opportunity to purchase the vehicle at auction. And that is the unfortunate part, because maybe you had 13,000 and could have bought the vehicle outright for 13,000, but you didn't, and you didn't have the opportunity to do that. And that's where I think that we need to come up with some understanding and some agreement. Now, that does mean you're going to have to come up with some money because you signed a contract and it was for a certain price, and the vehicle was sold at auction, and under statute, they're allowed to do that. But we need to come up with an agreement or some sort of understanding that is beneficial and mutual and at arm's length between yourself and the finance company. I hope all this makes sense.
Financiera. Ojalá que todo entienda lo que está pasando.
Sí, pues,
And I'm going to give you some time to process all of this.
Lo voy a-
And my suggestion would be, try to see what you can come up with in terms of money to pay off the debt at obviously a much lower rate, but something that is amenable to the finance company and yourself, because I think that that's, in all fairness, something that should be done. There needs to be equity and fairness that comes into play when we're dealing with these type of situations and these type of cases. I'm going to go ahead and give you some time. I'm going to give you, let's do latter part of May. The latter part of May as a reset date. May 25th, 2022 at 9:30. Any questions, Ms. Zamora?
¿Tiene alguna pregunta? ¿Alguna otra pregunta?
pues, no sé, pues yo soy sola, ya me recogieron el cheque de mi esposo. Digo, el mío nomás me dan el de mi esposo, ¿cómo voy a hacer para pagar eso?
I don't
Pero
know.
bueno, ok, sí, está bien.
Okay, well, just, I'm single, I'm a widow. They already took away my husband's check and it's just my check. I barely make it. How am I gonna pay? But okay, oh well.
Mr. Kettler, visit with the company, given the circumstances, given the fact that, what we come to know is that she's a widow, she's of limited means, and obviously see if the company would take this at a discounted rate if she was able to come up with some amount of money. What amount of money is, I'm going to let the parties try to negotiate that at arm's length, but I have a certain feeling and a certain, when it comes to these type of situations where the parties are not made aware, and the situation is one in which it's somewhat there needs to be some sort of negotiation.
For sure, Judge, and the hardship information she provided was really helpful. I'll definitely relay that to the client.
Okay, we'll see you on May 25th, Ms. Zamora. All right, that takes care of those in those cases that I have in person. I do have a few online. Let me go ahead and take care of those. Number 38, Jennifer Moreno. Is Jennifer Moreno present? Jennifer, can you hear me? You're on mute.
Okay.
All right, Ms. Moreno, you're here on CL 192594H. Are you represented by an attorney, Ms. Moreno?
No.
All right. And have you had any information or discussion with any representative from Portfolio?
No, I do know that I got served, but I didn't sign anything. And then I asked her for a card to see who she was, and they didn't give me anything. Well, what? So I didn't know if it was real.
Okay. Do you know anything about this debt?
I know it's Capital One because I saw it online.
All right, that's a credit card that you took out and you, okay. And do you know the amount? Mr. Kettler, do you know the amount that y'all are seeking to recover from Ms. Moreno?
Judge, the amount being sought in 2594 is 48.55 and 54 cents.
Sorry, can you repeat that one more time? The total amount?
Sure, $4,855.54.
$4,855.54.
Was it
Yep.
still getting interest rate after they already sent it to the collection office?
Yes, ma'am.
Because I don't remember owing that much.
Yeah, there's probably so much interest that has been accrued. Now, one of the things that you can try to negotiate with them is to see if you can have a payment plan, to come up with a payment plan and see if they'll waive the interest. Those are all things that I always encourage you all to try to, enter into an agreement. Now, I'm here to kind of play umpire, referee, big brothers to a certain extent, and to try to help the parties as much as I can, because I understand the situation that you found yourself in. Now, having said that, unlike the previous situation where we're talking about a vehicle that they didn't get any, they got the use of it, but they paid for it, right? While they had it, then they surrendered it, and then it was taken off to auction, and then it was auctioned at a discounted rate, and now they're trying to come after them for the difference. In these type of credit card cases, I look at it a little different because you did receive the goods and the services, right? You received benefit. You went and you charged it, you received a benefit, now you can't pay it back. Now, I'm sympathetic with the situation, but I'm also aware of the fact that you received goods and services, and when you receive the goods and services, you have to pay for the goods and services, right? If I go to HEB and I charge it on my credit card,
Well,
right? So all I'm saying, go ahead.
I was paying it. It's just that I paid one late, and they told me that they already had sent it to the portfolio
collection?
place, and they
Right.
weren't taking any more payments.
Okay, well, that's what we're here for, and that's what I'm here to make sure that they do take it, and that to make sure that if there's something that I can help to facilitate, that they get you back on track, and that we, in other words, I understand why they feel like they have that leverage, right? They feel like they have that leverage when there's no big brother, so to speak, here. But one of the things is that they filed this lawsuit and it fell in my court, and I'm here to try to make sure that justice is served, right? And I'm here to make sure that they get their money, and that they treat you fairly and equitably, and that you feel like you get out of this what you what you owe, right? I mean, you have to pay what you paid for, right? What the goods and services that you received, you have to pay for them. That's just right. Now,
I mean, I'm pretty good. I still have other credit cards and I'm paying them.
Right.
That's why I didn't understand this one. And that I only had gotten served and I never got any other letters from that company until I got this one. So that's why I'm here.
No, and I appreciate you being here, because if you were not here, then what's going to happen in just a little bit, once we're done with everybody that logged on, is everyone else is going to have a default filed against them. So by you showing up, a default isn't going to be filed against you. You will be able to at least negotiate at arm's length. You will be able to talk about, you know, the waiver of some of the fees, the interest and things of that sort, so that we can try to see if we can put you back on track. What they want is to get reimbursed for their expenses, right? Or their costs for the credit card. And what you want is to try to get this peace of mind off of your shoulders and have peace of mind and, you know, do the right thing, right? So ultimately, that's what we're trying to do. We're trying to put everybody back in the situation that puts everybody in the best possible position that they can. And I'm going to buy you time, right? I'm going to buy you some time to be able to talk to them. I'm going to buy you time to be able to see if something can get worked out before we have a contested hearing over this. Okay.
Okay.
All right. So no default judgment will be taken against you. Your general appearance here today will serve as a general appearance. I suspect we already have your email number so that you can log on for Zoom when we log on again on May the 11th at 9:30. Okay.
Okay.
And in the meanwhile, on the chat, there's two numbers that I'd like for you to write down if you've already written them down. That is for Megan Hale, and the other one is for Roush Sturm. Both those numbers, communicate with them. And again, now that Mr. Kettler is involved, they have to negotiate with you, or I expect them to negotiate. Maybe they don't want to, but I expect them to. And if they negotiate at arm's length, and then you come back with me on the 11th with a reasonable offer, or they come back and tell me, look, we offered this reasonable offer and she said no, well, then I'm going to look at that a certain way. If you come with a reasonable offer and they say no, then I'm going to look at that in a different way, right? Ultimately, in my mind, I already know, having handled so many of these cases, what is reasonable and what is not reasonable. And I'm trying to facilitate the parties coming to the conclusion of what is considered to be reasonable based on what you can pay and what they're willing to accept, to try to come to an end game, an end conclusion. Now, I will tell you, Ms. Moreno, and Mr. Kettler knows me well, he's appeared here quite some time, that if the firm is not willing to negotiate, then one thing that I do have is the power of my docket. And what I mean by that is I can put this case out so far into the future that they're going to have to discount it and basically forget about it, because one thing I can have control over is my docket and dates in which I give, right? So that's how I'm able to control the conversation, right? That's the power that I have. I control the conversation, but you all control the negotiation. I don't control that, right? So again, I want you to know, Ms. Moreno, that your case is viewed a little bit different than the other one, just simply because you received goods and services, you received a benefit, you received it, you used it, and now you need to pay it back. At what rate, at what amount, how much are they charging you in interest? All those things are negotiable, and you should be able to negotiate at arm's length, and then come back and report on May the 11th, okay?
Okay. At what time?
9:30 in the morning.
Okay. Thank you. Thank you, sir.
Any questions?
No.
All right. Thank you for logging on. We'll see you on May the 11th.
Okay.
All right, let's move over to number 40. That is CL 19-1075H, Portfolio Recovery Associates versus Aida Ocañas.
Here.
Aida Ocañas. Ms. Ocañas, are you represented by an attorney, ma'am?
No, sir.
All right. And have you had any opportunity to confer or visit with any representative from Portfolio Recovery Associates with respect to your debt?
No.
All right. And what are we talking about here, Mr. Kettler? What kind of debt are we talking about? Is it a credit card? Is it a...
Oh, I'm sorry, Judge, one moment. Yes, it's a Beals account that's the underlying one.
A Bell's account. Does that ring a bell, Ms. Ocañas?
Yes, sir.
Okay. And again, very similar to the commentary that I had for Ms. Moreno. When a Bell's account is taken out, you go, you charge it, you receive goods and services. and then, life happens and you can't make payments, and then, fees start accumulating. Very similar to the previous situation, I'd like to reset this case for May the 11th. I hope you were listening to what I gave and the explanation that I gave. I'd like for you to communicate with the company to try to see if something can get negotiated. Obviously, interest is a negotiable part of the equation. And then whether or not how the payments can be made to put you back on track to making some of those payments to pay off what you received, the goods and services that you received. And we'll see where we're at on May the 11th. But again, as I mentioned before, negotiating at arm's length is what I'm here to try to facilitate. And I want to make sure that it's reasonable to both parties. And we'll go from there, and we'll see what y'all can come up with. Okay.
Okay, thank you so much.
Any questions that you may have for me?
No, sir.
Were you able to get those two numbers to try to communicate with the firm?
Yes, sir.
Perfect. I hope that they negotiate with you at arm's length and that you're able to communicate with them. I know that sometimes they feel like they have all the leverage, but now that you're in this realm, we control some of the equation as well. So that's where I'm hoping that you all can negotiate at arm's length.
Okay, thank you. Appreciate it.
You're welcome. Let me move over to number 50, and you're excused, by the way, Ms. Ocañas. We'll see you on the 11th. Number 50 is Mrs. Crystal Sanchez. Ms. Crystal Sanchez, are you there? I have a Tiffany Rush.
That's on my case, Judge. She's the honor petition.
Oh, okay. All right. And then I have Mr. Dimas is also on that case. All right. And how about Araceli? You have an Araceli.
I'm here.
Okay. What case are you here on?
I have a paper here that it says Security Service Federal Court Union versus myself, Araceli Trevino.
Okay, that's number 52. Ms. Trevino, before moving forward, let me ask you, are you represented by an attorney?
No, I'm not.
All right. And do you have, or have you had any communication with anyone with respect to this debt that is being sought against you?
No.
Okay. And are you aware of what the debt is?
More or less, I really don't know. I might have a clue, but I don't know if it's.
All right. Were you able to hear kind of the explanation that I was giving everyone else about these debts and how they, the way the court looks at them, and how I hope that the next couple of weeks will kind of play out? Were you able to hear that and understand that?
Yes, more or less, yes.
Okay. So what I'm going to do, Ms. Araceli, is that today a default judgment will not be taken against you because you are present here today. And
Okay.
I am going to reset your case for May the 11th at 9:30 in the morning. I am
Okay.
going to ask that you look at the chat, and the chat has two numbers that you will then use those numbers to communicate with the representatives from the attorneys that represent the collection agency or the company that says that the debt is due to. And I'm going to ask that you try to work something out to see if something can get worked out. If it can get worked out, great. And if it can't, I want to hear from you all on May the 11th to see who is, kind of see what's being discussed and why there hasn't been a solution or a resolution to the case. Sometimes the solution is because the parties are too far apart, and my job is to see if we can bring them together. And sometimes, the credit company is not being reasonable with, moving to negotiate, and then I'll take that into account. And sometimes, Mr. Vino, the debtor doesn't, can't afford to pay or isn't willing to pay, or sometimes they have a legitimate defense, and we will hear it all. But between now and May the 11th, I'm going to give you the time to negotiate. Okay.
Okay. The thing is, I don't know if I'm correct on this, but is this for something that happened 5 years ago for a truck?
Is it Mr. Kettler about a vehicle?
Judge, I do show that the underlying contract was related to a vehicle.
Same situation where the vehicle was sold and surrendered and sold at auction, that kind of situation?
I believe so.
Okay.
Yeah, because I turned it in because at the time my husband got sick. He was the one using that truck. And since he got sick, I was the only one employed. And that's why I decided to turn it in. And unfortunately, my husband passed away. And so now, I'm the only one working with my 2 kids.
Okay.
And
Were you the primary lien holder on this, or was your husband?
Yes, it was me.
It was you. Okay.
Yes.
All right. Well, Mr. Kettler, please jot that down that, one of the lien holders, maybe a secondary lien holder, has passed away, leaving Miss Davino here, a widow with minor children. Again, I always view these a little different because it's an unfortunate situation. A lot of times people, in an effort to do the right thing, and the right thing is I can't afford it. It's not a, come catch me if you can. It's I know I have a responsibility, and and you surrender the vehicle because you're unaware of what's going to happen after you surrender the vehicle, right? And so sometimes you walk into a dealership and they paint you a pretty picture. They throw you all the bells and whistles. They offer you free oil changes for life and free coffee every time you come in to have it serviced. What they don't tell you is if you can't afford the vehicle that you're trying to buy, or if life happens and you cannot afford the vehicle thereafter, that they're going to take that vehicle no matter how they get it. And I appreciate the fact that you actually surrendered it, right? And then what happened was that they went and they sold it at a sale proceed. In your case, they sold, it was a $43,000 vehicle and they sold it for $27,000. And now they're trying to come after you for the deficiency of almost $16,000. And that's the problem that I feel a certain way about these type of cases, because they didn't allow you to bid on it with everyone else, and that would have been a great opportunity for you to have bid on it just like everyone else, right? And bought it for for $27,000, even though you owe 43. But they don't give you that option, and that's not something I can control. That's not something the bank can control. That's a legislature,
I understand.
that have written those laws the way they are. But what I can do is I can try to see if there's something that you can afford to write it off, because clearly the bank is in the business of not holding on to inventory, but B, they didn't have a problem charging it off and selling it for $27,000. Right? They didn't have a reserve price. They didn't have any of these type of safety mechanisms to try to prevent you from being harmed. And so for that reason, I want to make sure that you are treated fairly in this negotiation. So is it a debt that you owe? Yes. Is it something you have to pay back? It's something that you have to negotiate to pay back. And I'm going to give you some time to do that. I know in the other case, I gave that individual, that lady, a little bit more time. I gave her, was it May the 25th? I want to make sure I give you the same amount of time, because these are a little bit more delicate and difficult to work through. What day did I give her? May 25th. All right, I'll give you the same day, May 25th.
Okay. All right.
Any questions?
No. Would I receive another email with the Zoom meeting?
Yeah, a day or two before, we'll go ahead and call you with the Zoom link. We have your email. So a day or two before, we will email you with a Zoom link.
Okay, perfect.
All right, any questions?
No, that's it.
All right, thank you so much.
Thank you.
All right, let's go back to number 50, Crystal Sanchez. You are now present. Ms. Sanchez, are you represented by an attorney?
No.
All right, and you have heard what I have been discussing with others this afternoon.
Yes.
Have you had an opportunity to review with anyone about this debt that you have?
No.
All right. And again, I'm going to treat your appearance here today as a general appearance and reset your case for May the 11th. And that'll be at 9:30 in the morning. What kind of case is this, Mr. Kettler? Is this a credit card case or a vehicle surrender kind of case?
Judge, it's a vehicle surrender type of case, retail installment sales contract.
Okay. Same situation, Ms. Sanchez, as the previous one. You surrendered the vehicle because you couldn't make payments, and unbeknownst to you, they auctioned the sale. That kind of a situation?
Yeah, I have a question. The time span from this account has already been past the statute of limitations of 4 years, and I'm barely getting notice of it now. I did review my credit report, and I have documentation. I know Santander, the original company that I owe to, was charged, they had a lawsuit against them because they were submitting incorrect information to the credit bureaus. So I went ahead and printed out my different credit reports from 3 different creditors, Experian, Equifax, and TransUnion, and they all have different information. So, but all of them, I have one from January 2016. I have one from June 2017, June 30th. So I'm kind of confused as to what is the date they're going by.
Okay, so and again, I can't give you legal advice other than to, like I said earlier, I'm just the kind of the referee here trying to arbitrate this situation. I know that one of the situations or one of the questions that you have is, since the day that this was filed to today, it's been, over a statute of limitations. The statute of limitation is actually told the moment you get the lawsuit is filed and you get served. And it looks like this was filed back in 2018 and you got served back in 2018. So I think that, and I'm just guessing here, but I think the statute of limitation is a non-issue. Now, who holds the debt, who is seeking to recover for the debt, those are all legitimate questions you have, legitimate issues that you should bring up, and we can leave that for another day. But
I do believe because my dad, I'm not sure if my dad is the primary or if he was just the co-signer. And I know he spoke to someone like a while back. My daughter was still in a car seat and she's already 10. He tried to do some sort of negotiation with them, and they were trying to collect $8,000. But he told them, look, my daughter doesn't, I was making like $150 a week. And it was just him on his own, trying to pay his own bills. So they wanted him to pay 2 payments of $4,000. So and this is what he told me. I didn't speak to anybody. I don't know what was told between them, but I know he spoke to an attorney, and the attorney told him, don't pay them. So my dad left it alone. He didn't say anything about it anymore, and now we're here. So my thing is, if I have to make an arrangement, yes, I understand. I'm a single parent with 3 daughters. I don't make that much. I can offer to pay something, but it goes back to that. They wanted me to pay $4,000. I had to put my school on hold because I can't afford that either.
Right. So again, as you've heard me say before, I feel a certain way about these type of cases, and I hope that they negotiate with you at arm's length and that they're reasonable in their negotiation. You brought up some serious concerns and serious issues. This is a situation, Ms. Sanchez, given that I would, if it were me, I would communicate with them, see if something can get worked out. And if not, you might want to retain an attorney to see if you have other issues that are there that you might be able to look into in terms of who holds the debt, and all that comes with it. I mean, those are, again, legal issues that you need to explore with an attorney to see where you stand legally. I don't think the statute of limitation, as you brought up, is going to be an issue, but I know that for you to be thinking in that direction, I think that you've already looked into some of those issues.
Yes. Now, I have a question. I don't know if he mentioned the amount that was owed.
He didn't mention it because I don't know the amount that's owed. So, Mr. Kettler, do you have that offhand?
I do, Judge. The amount being sought from plaintiff's original petition is a little bit above $8,000, $8,105.71.
Okay. Can I have the amount that was, because this vehicle was taken from a body shop. They picked up the vehicle, it was getting fixed, and they picked it up from the body shop. So I want to know how much was it the vehicle was sold for. because it was auctioned off.
And that's one thing that we could provide to you later. In addition, if you do take advantage of that phone number, that's something that they could also, the principal firm Roush could provide you that documentation. I did have a quick question for you though. You had mentioned earlier that your father had called in and tried to make an offer, and they offered just to do 2 pays of $4,000 each.
Yeah.
If you don't mind me asking, was that with the plaintiff Cascade Capital, or was that Santander?
I'm not sure. He said he spoke to an attorney. It wasn't the company per se, it was an attorney, and the attorney directed him not to pay because that was an unreasonable amount of payments.
Oh, well, I'm sorry. I just meant the offer. I do understand that an attorney and advisor to pay, but
It was like 8,000.
okay. I'm just trying to make better notes so that when I let Roush Sturm know about the hearing, that they're aware of that history, whether or not that was negotiated with Cascade or whether that was with Santander.
Okay.
But you're just not sure which one it was.
Not sure.
Sure, no problem.
Ms. Sanchez, this is a good opportunity for you to visit with them because we're looking on our end and it doesn't show any credits or any the gross proceeds from the sale of the vehicle. I think it was only, might have been 1,300. So again, I need you to find out that information, and then we can have a good conversation once we have more information on the 25th. Is that what day we're giving? The 25th of May.
May 25th at
Yes.
what time?
At 9:30.
Okay, perfect.
May 25th at 9:30.
So who would I need to call? Is it to negotiate?
You can speak the attorney Megan Hale at the number that's in the chat,
Okay,
or the law firm of Roush Sturm, which is also in the chat.
okay,
Were you able to get those numbers?
yes,
Perfect. All right, we'll see you on the 25th.
thank you so much.
You're welcome. Okay. Let me now go back, and Mr. Kettler, hang tight while I see if Ms. Savannah Gonzalez and Ms. Garcia are present and ready to maybe make an announcement before we take default on all the other cases.
Sure,
Ms.
Judge.
Gonzalez, Ms. Garcia.
Good afternoon, Your Honor.
Okay, I'll come back to him. Okay, Ms. Gonzalez, Ms. Garcia, F 4971-21-8 in the interest of Aiden Dimas. Where are
Yes.
we?
Judge, good afternoon. Savannah Gonzalez for Javier Dimas. I believe we do have an agreement for temporary orders, and then we would need to come back once we've done a little bit more discovery exchange.
Okay, and would we need Mr. Dimas and Ms. Rush to testify here today? Or do you want to just submit the order, an agreed order? You want to
I
ask
think
them?
we put it on the record, Judge, just so that everyone's comfortable with it. Make sure we're on the same page. What do you think, Ms. Garcia?
Yes, I agree, Your Honor. Elizabeth Garcia for Ms. Rush.
Okay, let me just have Ms. Rush and Mr. Dimas please raise their right hand. Do each of you sort of tell the truth, the whole truth, and nothing but the truth, so help you God? I'm going to start with Ms. Rush
Yes.
and Mr. Dimas.
I do.
Okay, perfect. Now, you're going to hear that Ms. Gonzalez and Ms. Garcia are going to be putting some stuff on the record. In just a minute, they're going to ask you whether or not that's your agreement. We just need to know that that's your agreement for the record, okay? All right, Ms. Garcia, Ms. Gonzalez, whoever
Yes,
would
Judge.
like to put it on the record.
This is a modification, Judge. We have had a reduction in wages since the last time the court heard this. At this time, Mr. Dimas is making approximately $15 per hour with a 40-hour work week. He's getting a credit for one additional child outside of these proceedings. We've calculated at this time for just child support, his total will be $391.25 with that support obligation to begin April 1. While we have not exchanged discovery, the agreement is that if there is a variance in actual wages, Ms. Rush can urge that and we'll tack that onto the arrears, if any, at the final hearing.
Correct.
Everything regarding possession and access to remain the same at this time, Judge. This is strictly a modification of support at this time.
Okay, Ms. Garcia, anything to add?
The only other thing that I would add is that Mr. Dimas does have also a medical support obligation, and we're not waiving our right to recover for the medical support obligation, even though we are agreeing to this temporary reduction for right now and not, I mean, I guess he's just in a position where he can't also pay for medical support.
Okay,
But we're not waiving our right to recover because Ms. Rush does have her son on medical insurance and that has a cost to it.
no problem. All right, as long as that's included in the order, just so everybody can be clear.
Yes, Judge, we have no objection to that.
Ms. Rush, did you hear the agreement that was agreed to in principle by Ms. Gonzalez and Ms. Garcia?
Yes.
And are you in agreement with that?
Yes.
All right, Mr. Dima, same question. Did you hear the agreement that was read into the record by Ms. Gonzalez and Ms. Garcia?
Yes, sir, I did.
And are you in agreement with that?
Yes, sir.
All right, there's still a lot of work to be done, Mr. Dimas, Ms. Rush. Your attorneys still have a lot to do. This is just the first step of a few other steps that we have to get through so that we can try to get both of y'all on, to move forward in your lives, right? And to continue to support a child and to love a child and to care for a child and to cohabitate or co-parent a child as you move forward as a child grows older. So again, let your attorneys do the heavy lifting. They know what they're doing and they're good at it. So trust in them, and we are here to assist in whatever way we can. Anything else, Ms. Garcia, Ms. Gonzalez?
No, Your Honor.
Judge, just to advise Ms. Garcia, I'll go ahead and prepare the order in the interest of time because I know he's likely going to get that garnishment on the 1st. That won't be consistent with these rulings, but I'll circulate it for signature. Judge, do you want both parties to sign as well or just the attorneys?
Just the attorneys at this point, since they already agreed that that's the agreement. Attorneys just signature, and then when you submit it to the clerk, if you can submit it by today, tomorrow, call us. We'll pull it from the clerk's office because otherwise it'll sit in the clerk's office for a few days. We'll pull it. If you call us, we'll pull it, we'll request it, and I'll sign off on it.
Okay, Judge, let me get cranking it out and hopefully I can get it to you before 5 o'clock.
All right. If not tomorrow's still the 31st, but call us, please.
Oh, that's right. There's 31 days. Yes.
Yeah, otherwise it'll sit there for a while.
Okay.
Thank you.
Thank you, Judge. Will we be
Good
excused?
luck. You're excused.
Thank you.
Bye.
All right. Now, I believe we have an Andres Romo. See if Mr. Romo has a case, and if so, number 47. All right, Mr. Romo, can you hear me?
Yes, Your Honor, I can.
All right, this is CL 19-1844H, Portfolio Recovery Associates versus Andres Romo. Mr. Romo, are you represented by an attorney?
No, Your Honor.
And Mr. Romo, have you heard about some of the proceedings that we were having earlier, conversations we were having earlier? I was asking if you've others, and I'll ask you the same. Have you had any communication or any conversations with any representative from Portfolio Recovery Associates?
No, Your Honor.
All right. And are you aware of what this debt is about?
No, sir.
Okay. Let's see if we can find out. It's a GameStop debt. Are you aware of a GameStop debt?
Yes, Your Honor.
All right. And how much are we talking about here, Mr. Kettler?
Oh, pardon me, Your Honor. We're looking at judgment just a little bit over $1,100.
And so is this a debt where, Mr. Romo, you may have gone into GameStop, bought a couple of consoles, maybe a couple games, and charged it on a GameStop account and then make payment on it?
Yes, Your Honor. What happened was I was paying it, but I got I had some financial trouble where I was no longer able to make payments on it, and it kind of just spiraled out of control. And I guess they sold it to this company, and just recently they just filed me. They just sent me a letter about this court hearing, but
so
they never really sent me a letter. Just
okay, no, I understand. And like I said before, in situations where someone goes and uses a credit card to receive goods and services, and they receive the goods and services, and they still, I'm assuming they didn't repossess your PlayStation or your games, you still have that. In situations like that, I would really like for you to negotiate with the company to see if you can come up with a payment agreement And I'm going to give you a little bit of time to be able to do that. And the date that I'm going to give you is May the 11th. Okay, so please write that down, May the 11th. And on the chat, if you're able to see the chat, there's 2 numbers to 2 attorneys that I'd like for you to make contact with to try to be able to see if you can work out some sort of payment agreement. Okay.
What time, sir?
At 9:30, May 11th at 9:30. Now, what's going to happen is that you're going to reach out to them. You're going to see if there could be some payment arrangement. If y'all can come to an agreement, then on that day, that agreement's going to be read into the record and I'll accept it. If at that point there is no agreement, then I want to know why is there no agreement? Is it because you didn't call, or is it because they weren't willing to negotiate with you? Because this is a situation where there may be some fees, interest that accrued, and maybe they'll negotiate with you. But again, I go back to you receive goods and services, and those goods and services need to be paid for. And so hopefully they'll agree to some payment arrangement that'll help you given your current financial state. Maybe you're in a better financial state than you were at the time. Maybe you were in the same financial state as you were at the time, but nonetheless, hopefully y'all can come to some agreement. Okay.
Okay.
All right. So are you able to see the phone numbers on the
Yeah,
chat?
I have it written down.
Perfect. Okay, Mr. Romo, we'll see you on May the 11th at 9:30.
Thank you. Have a good day.
You too. Okay, now, Mr. Kettler, what I'd like to do is, as I always do, and I think you're aware of it, is I'd like to take default on all those that have not appeared in person or online, and I'll do them all at the same time.
I understand, Judge. I have a couple special handling cases I'd like to address before we move on to those. Would that be okay?
Sure. What number are they on the docket? And then we can remove those.
Sure. Well, maybe not necessarily remove. The first one I have, Judge, is number 3 on the docket, Mercedes and the Caballeros. For that one, we're looking to move to judgment only to Miss Elizabeth Caballero and an oral non-suit for Orlando Caballero.
All right, oral non-suit. And the order already reflects that, correct?
Judge, I don't believe that the order would reflect that. I believe the only order that may be in your queue, if it even is in your queue, would be a motion for default. But I do show that service hasn't been perfected against Orlando.
Why don't we do this? Why don't I reset it for May the 11th? That way you can submit the appropriate order, and then we can just go ahead and take care of it that way. That way there's no confusion, and or I could even do it sooner than May. If you don't mind logging on next week, I can do it next week.
I think May of the 11th would work fine, Judge.
Okay. I'm just going to go ahead and reset this to May the 11th at 9:30, and then we can handle it there, and we can handle it in the appropriate manner with an order that's already been submitted that reflects what you all are seeking to do.
For sure.
Okay.
And then the last special handling one that I have is number 44. That's going to be Rocha. Looks like appearance had been recently made by Tom Thomas's office. And for that one, Judge, we're looking to withdraw the motion and to see about possibly scheduling a status conference. If that May 11th date would work, then
Sure.
That would be us.
No problem. We'll give you May 11th, 9:30 for status.
Thank you, sir.
Okay, as to all the rest, if you could just grant me a couple of minutes so that I can read the names and the cause numbers into the record, and then you can take a default judgment as to all of them jointly.
Yes, sir.
All right, court's going to call with CL 190321H, TD Bank versus Juliana Albino. CL 187204H, Crown Asset Management versus Jeanette Arispe. CL 190806H, Cascade Capital versus Santiago Castillo Jr. CL 190454H, Cascade Capital versus Jose Chapa. CL 201264H, Capital One Bank versus Cynthia Cruz. CL 190437H, Portfolio Recovery Associates versus Perla de Leon. CL 186518H, Cons Appliances versus Salvador Estrada. CL 191345H, Portfolio Recovery Associates versus Javier Fernandez. CL 204318H, Synchrony Bank versus Susana Flores. CL 186097H, Portfolio Recovery Associates versus Omar Galvan. CL 185473H, Cascade Capital versus Arturo Garcia and Rosalinda Navarro. CL 183279H, Portfolio Recovery Associates versus Isela Garcia. CL 185129H, Cascade Capital versus Sofia Garcia. CL 193222H, Cascade Capital versus Elizabeth Garza and Adan Garza. CL 194706H, Portfolio Recovery Associates versus Selma Garza. CL 183984H, Portfolio Recovery Associates versus Vanessa Garza. CL 190796H, Cascade Capital versus Ofelia Gomez. CL 194714H, Portfolio Recovery Associates versus Cecilia Gonzalez. CL 190319H, Cascade Capital versus Emmanuel Gonzalez. CL 193089H, Jefferson Capital Systems versus Camilo Guerrero. CL 187013H, Velocity Investments versus Hugo Alberto Guerrero. CL 195778H, Portfolio Recovery Associates versus Kelsey Hernandez. CL 190803H, Cascade Capital versus Oscar Hernandez Jr. CL 194452H, Portfolio Recovery Associates versus Daniela Haragui Reynaga. CL 190356H, Cascade Capital versus Henry Jimenez. CL 183193H, Portfolio Recovery Associates versus Clemencia Holma. CL 191536H, Jefferson Capital Systems versus Alex Jones. CL 186702H, Portfolio Recovery Associates versus Rogelio Ledesma. CL 200147H, second round subsidiary assignee of Community Bank Victoria's Secret versus Joshua Longoria. CL 194648H, Portfolio Recovery Associates versus Ramona Lopez. CL 186519H, Cons Appliances versus Joshua Mar. CL 191407H, Portfolio Recovery Associates versus Javier Martinez. CL 210142H, Portfolio Recovery Associates versus Melissa Molina. CL 194447H, Portfolio Recovery Associates versus Raimundo Morales Jr. CL 185865H, Cons Appliances versus Mady Mosqueda. CL 190196H, second round subsidiary of Walmart Credit Card versus Paula Flores. CL 194023H, Portfolio Recovery Associates versus Cynthia Perez. CL 190192H, Cascade Capital versus Delecia Rodriguez and Emmanuel Galaviz. CL 193058H, Cons Appliances versus Norma Rodriguez. CL 195047H, TD Auto Finance versus Benito Ruiz. CL 187228H, Discover Bank versus Imelda Salinas. CL 186723H, Portfolio Recovery Associates versus Armando Torres. CL 194683H, Portfolio Recovery Associates versus Diana Vasquez. CL 203155H, Security Credit Services versus Edgar Villarreal. CL 196343H, Synchrony Bank versus Jessica Zamora. And finally, CL 195509H, Synchrony Bank versus Dora Zamarita. In all these cases that were called, the court has called out their names here in the courtroom. They have not appeared. They have failed to file an answer. Judicial notice is taken on all cases, including the filing of the action, the citation, and the fact that there has been no answer on file. You may proceed, Mr. Kettler, with any announcement you care to make on these cases.
Yes, Your Honor, we're here today on various plaintiffs' motions for default judgment, all arising from debt claims. As you had mentioned, the court has taken judicial notice of all documents on all files. Service on these cases should be perfected, returned, and on file with the court. And to date, no answers for these cases appear to be reflected. As such, we respectfully request judgments for the amounts sought in these cases.
In all these cases, a default judgment will be sought in the amount that has been provided to the court by plaintiff's counsel. We'll sign off on those, Mr. Kettler, and file those with the clerk.
Thank you, Judge. And I believe that's it for me today. May I be excused?
Your excuse. Thank you.
Thank you, sir.
Have a good one.
Y'all too.
That concludes our docket. Court's going to log off.